Madam Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks.
Without objection.
Madam Speaker, I rise today in support of the rule and the underlying legislation. The Congressional Review Act resolutions must follow a prescribed form according to law. This rule provides for consideration of H.J. Res. 111 in keeping with that form. Madam Speaker, we're here today to prevent federal overreach by the Consumer Financial Protection Bureau, also known as the CFPB. According to the D.C. Circuit Court, this unaccountable government agency has more unilateral authority than any single commissioner or board member in any other independent agency in the U.S. government. On July 10, 2017, the CFPB exercised that vast authority by issuing a 776-page final rule that restricts the ability of consumers to enter into arbitration agreements. The CFPB's misguided rule effectively eliminates arbitration clauses, instead forcing consumers into significantly more burdensome court proceedings. Eliminating this overbearing rule is a big win for consumers. Arbitration is an alternative to the judicial system, and it often results in a better outcome for consumers. According to the CFPB's own study, arbitration can be up to 12 times faster than litigation. This study also found that a class action lawsuit's average payout was just $32 per person, not even close to the $5,389 awarded on average from arbitration. Moreover, it costs less for consumers to file an arbitration complaint than it does to file a new complaint in federal court, making the arbitration system more accessible to all Americans. Arbitration allows parties to use an independent mediator instead of hiring expensive lawyers to settle a dispute. While the rule promulgated by the Consumer Financial Protection Bureau is a bad deal for consumers, it is a huge win for trial lawyers, who make an average of $1 million per case. The legislation being considered today would eliminate the CFPB's prohibition on an individual's right to enter into contracts that include arbitration agreements. The Congressional Review Act allows Congress to eliminate a rule from the executive branch and prevents a substantially similar rule from being proposed in its place. Checks and balances between the 3 branches of government are the cornerstone of our Constitution. The Congressional Review Act allows Congress to exercise our Article I authority and stop executive overreach that was never intended by the original legislation. The Congressional Review Act is a powerful tool because it only requires 51 votes to pass in the Senate. To date, Congress has passed 14 CRAs that have been signed by the President. One by one, we have eliminated Obama administration rules that harm Americans and small businesses across this country. Despite the work we have ahead, these CRAs are important and bring regulatory relief to millions of Americans. President Trump campaigned on a promise to end government overregulation that hurts Americans and small businesses. He turned those words into action by signing an executive order that requires 2 regulations be eliminated for every new regulation that is proposed. President Trump has exceeded those expectations in his first 6 months. For every new proposed rule, he has eliminated 16 regulations. Unfortunately, he has limited tools to rein in the Consumer Financial Protection Bureau because it was designed to be unaccountable under Dodd-Frank. This is an agency that continues to be run by an unchecked director. The structure of the Bureau has even been ruled unconstitutional by the executive branch. A few weeks ago, the House of Representatives passed legislation to restructure the Consumer Financial Protection Bureau, restoring congressional oversight duties and moving the agency back under the regular legislative appropriations process. I hope the Senate will consider this bill and bring accountability to the Consumer Financial Protection Bureau. I urge my colleagues to support this resolution and the underlying bill and eliminate the bad anti-arbitration rule issued by the Consumer Financial Protection Bureau. I reserve the balance of my time.
The gentleman from Colorado, Mr. Buck, reserves. The gentleman from Colorado, Mr. Polis, is recognized.
Mr. Speaker, I rise in opposition to the rule and the underlying legislation, H.J. Res. 111, disapproval of the Consumer Financial Protection Bureau's arbitration rule, and I yield myself such time as I may consume.
Without objection.
Before turning to the underlying legislation, I want to raise concerns about the bulk of the work this week, which is a so-called minibus appropriations bill, in which this body will seek to spend over $700 billion of deficit expenditures. That funding bill combines 4 major appropriations bills and represents more than half of discretionary spending. It includes our spending for the legislative branch, veterans, energy and water, and Department of Defense. Unfortunately, there's additional deficit spending that my colleagues across the aisle have decided to put in the bill, providing $1.6 billion to build a border wall, directly contrary to the promises that President Trump made on the campaign trail that another country would pay for the wall. Republicans are seeking to pass the bill to you, Madam Chair, and our fellow taxpayers to pay for this wall in direct violation of President Trump's promise. They also stripped out a bipartisan amendment by Representative Lee that would end the 2001 AUMF and require Congress to come up with a new authorization for the use of military force within 8 months. It was placed into this bill in committee. Representative Lee's amendment was stripped out by the Rules Committee, despite it being in the committee mark and despite the bipartisan support to require an authorization for the use of military force. We really need to start making some decisions about the direction of our military. Representative Lee's amendment would have forced Congress to have that discussion. Congress, unfortunately, seems to only work or works best when we're on the clock. The day or two before the expiration of funding, the day or two before an arbitrary time limit. This would apply to a similar test to force Congress to have the discussions around the authorization of the use of military force. I have certainly full confidence that had that timeline not been met, Republicans and Democrats could have provided additional short-term extensions for the current authorization of use of military force until such a time as Congress could come together to pass a new one and agree with the Senate and send it to the President's desk. On to the matters at hand. This underlying resolution of disapproval weakens consumer protections while protecting big banks rather than consumers. This rule was crafted by the Consumer Financial Protection Bureau to help restore consumer rights and give consumers the ability to join together when they're taken advantage of by big banks. Instead of debating ways to improve consumer protections or increase access to financial services, my colleagues instead have brought a Congressional Review Act resolution that would stop our own financial safety mechanisms from taking any future action on arbitration clauses in consumer financial products. Now, we've all seen these arbitration clauses. They're usually, you might need a magnifying glass because the font is small, the contract is large. Even sophisticated consumers often don't know that by unilaterally signing those rights away, they're removing their ability to redress their grievances in court, and in many cases, removing the ability to have any justice, because when you have a large class, each of whom suffers a small amount of damage, even the cost of administering an arbitration claim can be prohibited if the claim per affected individual is $50, $100, $75. Absent these kind of protections, you give broad license for big banks to rip off large numbers of consumers and take a small amount of money from each of them. That's what this rule is intended to prevent. The House Financial Services Committee did not hold any hearings on this rule. It didn't go through committee. It appeared just a few days ago. It was introduced. The Consumer Financial Protection Bureau didn't have the opportunity to testify about their study or their findings or the process they went through to finalize the rule, including input from the general public. Congress has authorized the Consumer Financial Protection Bureau to examine the use of arbitration agreements by financial institutions and consumer contracts, and if necessary, to take appropriate steps to limit the use of them, to prevent arbitration agreements from being forced on consumers. In any particular case, both sides can certainly agree to arbitration. Given the choice, many consumers will choose arbitration. This is about forcing consumers and giving them no alternative but to give away their rights to sue in a court of law in favor of an arbitration process. Consumer Financial Protection Bureau found that 90% of arbitration agreements built into the fine point of financial consumer products actually do prohibit class action lawsuits. In cases involving credit card issuers, companies being sued using the arbitration clauses buried in their fine print block class action lawsuits 65% of the time. And again, even with the lower costs of administering an arbitration case, it's prohibitive if the claim per person is relatively small. So we're talking about situations where people are illegally ripped off of $20, of $100 of their annual credit card processing fee, illegally charged. Their redress, absent a class action, is essentially non-existent. Because even though the costs of pursuing an arbitration case are significantly less than the courts, they still can either take up an enormous amount of time, or if you hire outside counsel, thousands of dollars. Thank goodness not the tens or hundreds of thousands of dollars that a full court case could entail, but certainly thousands of dollars. And if you were deprived of $30 or $50, are you just supposed to accept it? Or can hundreds or thousands of people who are ripped off band together and seek justice, as this rule would allow for? Long before the Consumer Financial Protection Bureau took any action, the Department of Defense already recognized the forced arbitration clause in consumer loans to service members, stripped away the rights of service members, and ultimately banned forced arbitration clauses in consumer loan products because we don't want people taking advantage of members of our military. So, too, we don't want anybody taking advantage of members of the American public. But we know big banks don't want consumers to have more power when it comes to financial products. They prefer that the deck remains stacked against consumers, even when a bank or credit card company breaks the law. When it comes to financial service products, most consumers are entirely at the mercy of our financial institutions. These arbitration clauses are buried in pages and pages of small print and disclosure, very technical for people with a college degree, no less a high school degree, no less not even graduated high school. The consumer simply doesn't have the ability to modify the contract before they sign it, take it or leave it, or negotiate on any type of footing equally with a bank. They're left with a take it or leave it choice, and according to the Bureau study, more than 75% of consumers surveyed did not know whether they were subject to an arbitration clause in their agreements, and less than 7% knew that those clauses limit their ability to bring a claim in court. That means 93% of the people who sign these agreements don't even realize they are signing their right to sue away. And that's because they're buried in fine print and unclear and run contrary to the fundamental American principle of the ability to seek justice when you are wronged. This final rule restores consumer rights to band together when there's a systemic and widespread form of misconduct by a bank. This resolution judicial approval would stop consumers from even knowing if others were harmed in a similar manner by the same bank or lender, so they could potentially band together. I'm glad that the Consumer Financial Protection Bureau final rule actually gave some power back to consumers, and now here we have the Republicans trying to take that power right away, giving it back to the big banks. Mr. Speaker, I'd like to enter into the record a letter signed by 310 organizations that include civil rights, faith-based, and consumer advocacy groups that support the arbitration rule.
Without objection.
In part, this letter, which I think my colleagues will find convincing and will appear in the record, and has 310 groups that have signed on in support of this rule, including groups from across the ideological spectrum, across the states, many faith-based groups, and so many others, including from my friend from Colorado's in my home state, the Interfaith Alliance of Colorado, the National Council of Jewish Women Colorado section, the NAACP State Conference of Colorado, the Colorado Fiscal Institute, the Colorado Council of Churches, the Colorado Alliance of Retired Americans, and many, many others. So I'm glad that this will appear in the record for all of Congress to see, and I would encourage my colleagues to read this letter and see who signed it before casting your vote on the repeal of this rule, this congressional disapproval resolution. So this will appear in the record, and I know that my colleagues will study that record before making their decision. Prior to the creation of the Consumer Financial Protection Bureau, federal consumer protection laws were enforced by a number of different regulators and different agencies. This was uneven, and after the 2008 financial crisis, I was personally glad that we were able to pull together the efforts to protect consumers in the Consumer Financial Protection Bureau. But despite their success, Republicans have been going after the Consumer Financial Protection Bureau ever since. Despite record profits by banks and Wall Street, here we are trying to go back to a time when there was nobody to keep them in check. Despite the Consumer Financial Protection Bureau returning nearly $12 million to harm consumers, the Republicans continue to attack the agency. There's nothing, this is entirely the purpose that the Consumer Financial Protection Bureau was created, this type of rule. Congress specifically authorized the Consumer Financial Protection Bureau to study specifically forced arbitration agreements and determine what steps were necessary. The Bureau undertook an extensive rulemaking process that had public comments. I hope my colleagues across the aisle who support this repeal, I hope they were active in that public comment process, because that was an important time to be heard. The banks participated in that, consumer groups, and so many other stakeholders before the final rule was issued. My colleagues across the aisle have not offered any evidence in support of this resolution of disapproval. Why are you seeking to strip rights away from consumers in this fashion? The Consumer Financial Protection Bureau found that just 400 consumers per year pursue claims in arbitration, with only 16 receiving any cash relief. Again, when you are ripped off of a relatively small amount of money, you don't have redress in the courts as a sole plaintiff. You don't have redress, I should say you technically do. You don't have an economic form of redress in the courts, and you don't have an economically viable form of redress through arbitration. So the only true mechanism, if you have 1 million people, each of whom are deprived of $20 or $50, the only realistic legal mechanism is a class action lawsuit, which this rule would protect. There's also no evidence to show, no studies. I would challenge my colleagues to cite them. If there are no studies to show that removing this type of clause can somehow increase costs to consumers. Frankly, this resolution of disapproval is just a giveaway to big banks at the expense of you, me, everybody who has a credit card, everybody who has a loan. The wrong direction for the country, and I reserve the balance of my time.
The gentleman from Colorado, Mr. Polis, reserves. The gentleman from Colorado, Mr. Buck, is recognized.
Madam Speaker, I yield 4 minutes to the author of this resolution, the gentleman from Pennsylvania, Mr. Rothwitz.
The gentleman is recognized.
Thank you, Speaker. I rise today to call on all of my colleagues to support this resolution and the underlying legislation, H.J. Res. 111. The Consumer Financial Protection Bureau's anti-arbitration rule will cause a great deal of harm to consumers, including consumers who wish to settle a dispute with a firm in a timely and effective fashion, as well as other consumers who will see their options and choices diminished and their costs increased by this rule. The CFPB's rule will hurt the very people the CFPB claims it is supposed to help, by depriving individuals of the efficient and effective process of arbitration. The CFPB itself acknowledged that arbitration is 12 times faster on average than class actions. In today's fast-paced economy, hardworking Americans may want to pursue a quicker option than becoming a party to costly and time-consuming litigation that can take years. Not only are class actions burdensome in terms of time, but they often produce negligible benefits for the plaintiffs in question. In fact, class actions reviewed in the CFPB study resulted in an average recovery of only $32 per class member. This is so minuscule that the firms being sued are forced to charge their customers additional fees, which fees may be larger than the initial recovery, to cover the costs of the firm's legal fees. This often leaves customers worse off financially than if they had never chosen to settle their dispute. Contrast this negligible or non-existent relief with the headache it causes consumers with the average $5,300 of relief that consumers obtained through arbitration in the cases that the CFB reviewed in its own study. Contrast the $32 average individual recovery as well with the average $1 million plaintiff lawyers make per settled case. Madam Speaker, consider also the fact that 87% of class actions generate no benefits for consumers whatsoever because they are dismissed by the court or settled with the named plaintiff only. In addition to the direct harm the CFPB's anti-arbitration rule will cause to consumers, it will also have negative effects on a variety of companies and firms that will have to prepare themselves for falling victim to costly litigation. In light of that, they will be unlikely to direct any financial resources toward providing their customers even the option for arbitration. In addition, many firms are unable to survive such costly litigation, meaning they will either go out of business or be forced to stop offering certain products and services. How will this benefit consumers? It won't. It will make their purchases costlier and the products and services they need more difficult to find. If we want to help ensure consumer recoveries and justice, and we all do, depriving them of the most efficient and most remunerative option is not the answer. Sadly, that is precisely what will result from the CFPB's misguided anti-consumer rule. The CFPB's anti-arbitration rule will close the door to recovery for consumers, but open the door for million-dollar trial fees, attorney fees. The underlying legislation considered today will reopen the door to consumer recovery. I thank the Speaker and I yield back.
I reserve the balance of my time.
The gentleman from Colorado, Mr. Buck, reserves. The gentleman from Colorado, Mr. Polis, is recognized.
It's wonderful to have so many Coloradans here, isn't it, Madam Chair?
Absolutely.
Thank you. Madam Chair, I yield 3 minutes to the gentleman from Texas, another great state that borders the state of Colorado, Mr. Doggett.
Well, it's included the state of Colorado,
Recognized.
or part of it. I thank the gentleman. You know, I think Republicans are just scared. They're afraid to leave town this week without doing another favor for Wall Street. And this proposal to undermine consumer rights is the next gift that they want to bestow on the big banks. Republicans can never seem to find their voice, no matter how outrageous the latest Trump tweet might be. They cannot pass meaningful legislation on other subjects, but they feel compelled to answer when Wall Street comes a-calling, as it has on this bill. Only last month, Republicans approved a bill to give Trump the power to fire the chief cop on the beat. That would be the director of the Consumer Financial Protection Bureau, who Trump could now dump for actually trying to do his job of protecting consumers from abusive financial practices. And of course, we see daily that Trump thinks the White House is just a new venue for the latest sequel of The Apprentice, with him declaring, "You're fired," to one person after another, no matter how much damage he does to our national security or to the economic security of families that are struggling to make a go of it all over America. Well, today's Republican gift to Wall Street is about denying any effective remedy to those who are abused by big banks. A bank can rightfully go to court if a consumer abuses it, and that happens every day in courts across America with good reason, because it's not a one-way street. But in the non-negotiable, deceitful fine print at the back of the contract, the bank can deny the consumer the very same opportunity to go to court if that consumer is abused. It's called arbitration. But what it really means is if a consumer has been treated wrong, neither a judge nor a jury can ever evaluate the facts and conclude for the consumer. And since usually the arbitrator depends upon the same bank or group of banks to get repeat business, the arbitrator has an incentive to rule against the consumer and for the bank. Often, arbitration is little better than going to the bank's own attorney and asking, do you think your client did anything wrong? And if so, should they do any more than say, I'm sorry? Arbitration is the very scheme that Wells Fargo relied upon to obstruct any opportunity for ordinary consumers who tried to hold their bank accountable for creating accounts to which they never gave any consent and charging them for it. Wells Fargo used those arbitration clauses to kick the consumers out of court and to continue its fraud against consumers across America for another 2 years. And that's the kind of practice that we'll have more of if this legislation is approved. You know, in the Military Lending Act of 2007, Congress showed the good sense to try to protect our service members who are defending our country all over the world in certain of their loan agreements from having a lender impose a mandatory arbitration agreement. And what today we should be doing is supporting similar protections for other Americans who can be exposed to the same type of abuse. Today's bill to undermine consumer protection is opposed by the Military Coalition and 29 other service member and veterans groups representing millions of people. This sorry bill is also opposed by a number, I think literally hundreds, of consumer, civil rights, labor, and community groups. All we're saying in rejecting this bill is to give consumers their day in court. Give them the same rights the banks want. In fact, treat consumers as if they were banks, because they should be treated with the same dignity and the same rights. And we do that by rejecting this bill and rejecting it soundly. I yield back.
Gentleman from Colorado Reserves, Mr. Polis.
Madam Speaker, I'd like to yield 2 minutes to the gentlewoman from Ohio. What? I reserve.
Gentleman from Colorado, Mr. Buck, is recognized.
Thank you, Madam Speaker. I yield 3 minutes to the chairman of the Financial Institutions and Consumer Credit Subcommittee, the gentleman from Missouri, Mr. Lukemeyer.
The gentleman is recognized.
Thank you, Madam Speaker, and also want to thank the gentleman from Colorado, Mr. Buck, for his help in quickly bringing this resolution to the floor. Madam Speaker, I rise today in support of this rule and the underlying resolution, which would block the Consumer Financial Protection Bureau from denying the American people the use of arbitration as a means to resolve consumer complaints. Since the creation of the Consumer Financial Protection Bureau, consumer costs have gone up, and access to financial products has been severely restricted. In some cases, access has evaporated altogether. The Bureau's arbitration rule is proof of what we've said for years. The CFPB does not operate in the best interests of American consumers. It does not protect the American people, their access to financial products, or the ability to achieve financial independence. Take as evidence the CFPB's own study on arbitration. It shows that just 13% of class action suits actually provided a benefit to consumers, with an average of payout of $32. Let me say that again. It was an average payout of $32. Arbitration, on the other hand, provides an average of more than $5,000. Let me say that again. Over $5,000 to the aggrieved parties. Again, these figures come from the Bureau's own analysis, their own study. The fact that they cannot somehow justify this rule is in the name of consumer protection should offend every single person on this floor today, Madam Speaker. Simply put, this rule is anti-consumer. It hurts the very people the CFPB purports to protect. It's yet another example of the Washington knows best attitude that makes the American people so mad. This is also why Congress has the oversight tools granted under the Congressional Review Act. And in this instance, it's time for Congress to intervene on behalf of the people we represent. We've argued about the CFPB in the past, but the reality is that this rule in particular will have devastating consequences for American consumers. It should serve as a dramatic wake-up call for the need to restrain what is the most powerful and unaccountable government agency in the history of our nation. From Pennsylvania, Mr. Rothfuss, and Chairman Henson for their steadfast leadership on this very important issue. I ask my colleagues for their support on the rule and the underlying measure. With that, I yield back the balance of my time.
I reserve the balance of my time.
The gentleman from Colorado, Mr. Buck, reserves. The gentleman from Colorado, Mr. Polis, is recognized.
Madam Speaker, I'd like to yield 2 minutes to the gentlewoman from Ohio, Ms. Capter.
The gentlewoman is recognized.
I thank the ranking member, Mr. Polis, for recognizing me and yielding me time. Mr. Speaker, I rise today to oppose the rule and underlying bill by my Republican colleagues. The Republican bill favors big Wall Street mega banks and financial interests over the American people. I would ask my Republican friends, don't you remember the financial crash of 2008 and who created it? Their bill repeals a new Consumer Financial Protection Bureau rule, which cuts down on those companies' abilities to use so-called forced arbitration clauses, which prevent cheated or defrauded consumers from going to court. In other words, they prevent the victims from going to court. They want to handcuff the customers, not the mega banks that took them to the cleaners. This takes us back to the days of when the fine print in the credit card or other financial agreement prevented consumers from banding together in class action lawsuits to challenge illegal behavior by the most powerful financial giants in the world. Try to deal with one of them as an individual. They don't even return phone calls, for heaven's sake. You get in that robo system for hours and hours, and then the phone call cuts off. Republicans want to dismantle the Consumer Financial Protection Bureau, even after the agency's work for consumers resulted in $12 billion in relief to 27 million Americans who were harmed, and that's just the beginning. Why is this Republican-led Congress so keen on protecting companies like Wells Fargo that used arbitration clauses and class action bans to create fraudulent accounts, overcharge customers with debit fees and mortgages, and even avoid responsibility for their misconduct, criminal misconduct? You can laugh. Come and meet the millions of people who've lost their homes across this country or are underwater on their mortgages. There is no justice for them. The idea that banks can rip off consumers by abusing obscure clauses buried deep in their contracts is totally outrageous. The Consumer Financial Protection Bureau's rule banning the use of these
The general
clauses
time's expired.
May I have an additional 30 seconds?
Happy to yield an additional minute to the lady from Ohio.
I thank
General
the
lady
gentleman.
resumes.
The Consumer Financial Protection Bureau's rule banning the use of these clauses is simply a common sense step to ensure that all consumers have equal access to justice. This is the people's house. We should protect consumers from the wolves. Our job is to keep them at bay, not make it easier for them to prey on the American people. This is not what President Trump ran on. I urge my colleagues to vote no and stand with America's consumers over special interests, particularly the financial predators that brought this country to ruin. And I yield back my time to the gentleman.
Reserve.
Gentleman from Colorado, Mr. Polis reserves. The gentleman from Colorado, Mr. Buck, is recognized.
Madam Speaker, I have no further witnesses and am prepared to close if Mr. Polis is prepared to close.
Gentleman from Colorado, Mr. Polis.
Yeah, I'm prepared to close. I yield myself such time as I may consume.
Gentleman's recognized.
Mr. Speaker, for months now, we've been debating bills that hurt hardworking Americans, bills that kick millions, tens of millions of people off health insurance, bills that gut safety and environmental protections that would keep our air clean, bills that prioritize the interests of Wall Street over Main Street. This is not just what my constituents it's not what my constituents want. It's also not what the constituents of many of us want. Madam Speaker, for this reason, Democrats have unveiled an agenda to increase wages, reduce costs for everyday expenses, and give workers the training they need to compete in 21st century jobs. Madam Speaker, if we defeat the previous question, I'll offer an amendment to the rule to bring up the Representative Pocan's Leveraging Effective Apprenticeships to Rebuild National Skills Act, H.R. 2933, which would promote effective apprenticeships that would give students and workers more opportunities to find, well, good-paying jobs. Madam Speaker, I ask unanimous consent to insert the text of my amendment in the record, along with extraneous material, immediately prior to the vote on the previous question.
Without objection.
So, Madam Speaker, we have less than 4 days left before the scheduled August recess. I hope in that time we can focus on strengthening the economy and empowering consumers rather than taking away consumers' rights like this bill does. We should focus on fixing our broken immigration system to create more economic growth and reduce our deficit. And we should create jobs and make sure that more people are covered by health care, not less. Instead, here we are, spending time on the floor of the House, stripping away consumer protections and spending American taxpayer money on an unwanted border wall in direct violation of President Trump's promise. Madam Speaker, I oppose this rule and I oppose the underlying legislation. I strongly urge my colleagues to vote no on both, and I yield back the balance of my time.
The gentleman yields back. The gentleman from Colorado, Mr. Buck, is recognized.
Thank you, Madam Speaker. The Consumer Financial Protection Bureau has been a continuous example of federal overreach. Once again, bureaucrats in Washington have created a rule that will hurt consumers and make their lives more difficult. The last 8 years of overregulation have crippled our economy. Today, we have a chance to end this anti-arbitration rule and empower consumers with an alternative to spending years in a courtroom. We can't let concerns about the trial lawyer lobby impact the way we treat consumers. Trial lawyers love this rule enacted by the Consumer Financial Protection Bureau because they'll be the biggest beneficiaries. They'll walk home with the big winnings while the individuals who have been harmed walk away with little. Arbitration allows harmed individuals to receive payouts on the merits of their case without enriching the pockets of trial lawyers at the same time. This legislation is for consumers. It's for the average American who relies on our financial system every day. I thank Chairman Sessions and Chairman Hensling for bringing this bill to the floor. I urge you now to vote yes on the resolution and then to vote yes on the underlying bill. I yield back the balance of my time, and I move the previous question on the resolution.
The question is on ordering the previous question on the resolution. Those in favor say aye. Those opposed, no. In the opinion of the chair, the ayes have it.
Madam Speaker, on that I request the yeas and the nays.
The yeas and nays are requested. Those favoring a vote by the yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered. Members will record their vote by electronic device. Pursuant to Clause 9 of Rule 20, the chair will reduce to 5 minutes the minimum time for any electronic vote on the question of adoption of the resolution. This is a 15-minute vote. On this vote, the yeas are 233, the nays 188. The resolution is adopted. Without objection, the motion to reconsider is laid on the table.